a tension-full atmosphere.
Yes,
All right, chalo.
we are not able to survive properly, Your Lordship.
For the state respondents, due to some personal difficulty, he has not been able.
Third time.
My lord, I know, my lord. Just now I checked the record, my lord, and I have been told, my lord, by the clerk
So
of,
what he is trying, sir?
my lord, I am seeking only 1 day's accommodation.
Yesterday also this was said. One day.
Too late due to, my lord, some personal difficulty, my lord. My lord, let the matter be fixed on any other day
It
except
cannot be fixed at your beck and call, na?
subject to the
She
convenience.
has to accommodate it, and we have to be accommodate ourselves also.
One last time, my lord, I am seeking.
Then you talk with Ayun Banerjee and come and tell us when we will keep it.
My lord, before such a talk, my lord, 23rd and 24th, my lord, these 2 days, my lord, I have some personal difficulty. But, my lord,
Up to 24th we have 24 তারিখ অনেক 23 তারিখ আছে কি করে?
my lord, just to recapitulate, my lord, I had concluded my arguments. Is for Mr. Banerjee to had made substantial arguments and he had further submissions to make. My lord, in the order dated 10 July 2025, my lord, there is a typographical error. My learned junior had mentioned it on Monday.
Yes, what is the error?
My lord, it's in the second paragraph, my lord. The second last line of the second paragraph. Instead of EC 134, it should be EC 149.
আচ্ছা আচ্ছা,
My lord,
আসো by reason of a typographical error
But I
তুমি দেখো
on behalf of the appellant, my lord. My lord, kindly peruse your lordship's order dated 19th of June 2025, my lord, wherein my lord was pleased to direct to file affidavits, my lord. My lord, we have only received the affidavit in opposition on 14th evening. I will only pray if my lord will kindly grant me a leave to file the
it is that same question.
yes, something different. No, here the matter.
You have gone to Supreme Court.
Not yet, my lord. Not yet.
I am filing the opposition.
My lord, give me some time to put in the reply, my lord. So it is ready, but it is
Mr.
not.
Haldar, learned advocate appearing for the respondents, files the affidavit in opposition. Stop. Let the same be kept on record. Mr. Mukherjee, learned advocate appearing for the appellant, submits that a copy of the said affidavit in opposition has been belatedly served upon the appellant, and as such, he prays for extension of time to file the affidavit in reply. Stop. Let such affidavit in reply be filed
Well, next week we'll file.
within by let such affidavit in reply be filed by আছে কত তারিখ 18 by 25th, leaves the matter for further consideration under the same heading on 30th July.
I'm grateful.
Mal.
My pleasure. Reporte কি ছিল গল্প? But in last occasion submitted that, my lord, I am private respondent. 6 I am appearing for the state. That out of 39 decimals of land, government acquired 18 decimals. 21 decimals left out. Out of 21 decimals, my lord, I purchased 4 decimals of land from the bona fide owner. Thereafter, I applied for mutation. It has been recorded in our name. Then we applied for conversion. 4 decimals, it has been converted in our name as Bastu. On the last occasion, my lord, query was that one person proved, another one, that copy I mistakenly not given, it is with us. My lord, so 4 decimals,
What is that?
but the 4 decimals has been recorded. Page 6, conversion.
Why didn't you file supplemented?
My lord, page 65,
You know that?
Your lordship, on the last occasion,
Huh.
your lordship has adjourned this
Then-
matter solely on the ground whether there is any provision of appeal against the final action taken under 10(4) of the West Bengal Highways Act.
Oh,
So
there is no, we have checked up, my lord, there is no further
there is
provision
no
of
further
appeal.
provisions.
Yeah.
Now, if I may, now your lordship, this entire proceedings was started.
but for whom?
I'm for the state, your lordship.
You're for the
State, I'm appearing for the state, your lordship. A report has been handed over on the last occasion.
Report, there is nothing I have checked up. Story, they have given the sequence, chronologically,
that
they have given
has
the
to be given. Your lordship would kindly
Now
this,
there is but
this,
an
appeal,
apparent. আচ্ছা তুমি
বলো
বলে
না।
দাও তুমি বলে দাও
this appeal is
just let us allow us
two three documents my lord would clarify the position.
allow us to go through the
Yes,
তোমার পড়া? পড়ো পড়ো আর তুমি পড়ে গেলে তুমি পড়ে নাও তার কি প্রত্যেকটা ওয়ার্ড So, Mr. Mustafa, you will be relying on those documents.
Yes,
Then then they must be given a copy.
General,
Mr.
one
Mustafa,
page
learned
supplementary
advocate
affidavit.
appearing for the appellate's prays for leave to file a supplementary affidavit. Stop. Such prayer is আর ঘাড়ে কটা মাথা।
7, Your Lordship, I appear for the appellant.
What are the applications about? There are four applications in connection with the appeal. Item number 7. Can 1, can 2, can 3, can 4. What are those?
Your Lordship, there's can 1 and can 2, Your Lordship.
See the list.
The CAN 4 is my application, my lord.
Oh,
I am the person whose property is now being sought to be sold. I must be candid, my lord. The application is taken out, but the application is not served on anybody.
Bojo.
You have just taken out the application. Yes.
My advocate on record tells me it's been served, Your Lordship.
You have got it? You
CAN
have got
4
the
you have got.
copy? Can 4.
Yes, Your Lordship. And this is the affidavit of service I'm filing there.
No, he has not yet.
CAN 4 my application, my
No, this is can 3 I'm talking about, Your Lordship.
We are talking about CAN 4.
Do one thing, you give a copy to her.
CAN 1, 2, 3 are your applications.
Yes.
All 3.
2 is our
Madam,
2 is our application which we are withdrawing in view of CAN 4.
Oh, acha. Give a copy to her. You take the copy, madam, come back on next Thursday. Yes, next Thursday.
इसको 1, 2, 3 में बोला है। और एक दूसरा record करो।
What you are saying, I can 2, you are withdrawing.
Yes, because CAN 4 is a my lord, application which includes all subsequent facts. My lord, CAN 2 was also in similar lines.
The same press.
Yes, similar
That is,
press. So CAN 2 I am withdrawing.
Are you annexing any new documents in CAN 4?
Yes, 1 or 2.
Not relied upon.
Yes, my lord. Yes, my lord.
Or
Those are all subsequent documents. Subsequent to CAN 2 also.
no, but even then.
It has to be an
Subsequent to CAN
application.
2.
It has to be an application in the proper nomenclature, na?
Your Lordship,
My lord.
30th August 2024, Your Lordship, the bank has taken physical possession over the property. I am for the auction purchaser, the successful auction purchaser, Your Lordship. Sales certificate is with me, Your Lordship. Till date, physical possession has not been transferred to me.
By
Sale
the
is,
bank.
confirmed in your
My lord,
paper.
the correct facts are these. My lord, I am the borrower. My defaulter.
It's been put up for sale, sold.
Sold. But
Sales
challenged on
certificate
the ground that bank did not take physical possession of the property and set it up for sale. The impugned order dismisses and cancels the sale on that basis that the bank did not have possession based on the law as on that day. Now today my learned friend is saying, since the law has changed because of Hindon Forge, that I should be getting the benefit and the impugned order should be set aside because in the meantime the bank has taken possession. That's her case, which
Absolutely.
possibly think she's going to argue.
And I'm grateful to my learned friend for placing my case.
Then today physical possession has been taken.
My lord.
Have you drawn up any proceeding towards such action?
No,
You are the borrower.
DRT proceedings pending at my instance, saying that
Are you enjoying?
But there's no stay before the DRT, Your Lordship.
not there. But my lord, my contention would be that an order impugned cannot be, my lord, set aside or assailed in appeal because of a change in law in due course of time. This will, my lord, 2015.
Lordship, before the DRT.
Milord, my writ petition was dismissed. That Milord, since the possession had not been taken and the property had been sold, Milord, the Honorable Single Judge was of the view that Milord, possession must always precede, physical possession must always precede sale. Milord, that was law at one point of time. After that, Milord, the Supreme Court, Honorable Supreme Court has clarified, Milord, in 2-3 decisions, saying that there is no dichotomy, Milord, in between this, Milord, physical possession.
Symbolic and physical.
Yes. Starting, Milord,
Even
from
if it
Nobel
is
Kumar.
symbolic, even if it is symbolic, bank can sell.
Yes.
Exactly.
And after that,
Mr.
bank.
Ghosh's contention is, if I've understood him correctly, is that law as it was on the date of the sale has to be applicable.
Unfortunately, that is not the law, because when Honorable Supreme Court, Milord,
Very well, we'll hear
explains a law, Milord, it dates back
No,
to the
Mr.
date.
Ghosh is wrong.
Milord, for a change.
and
For a
as
change.
always.
For a change, he is and he knows that.
He
Milord,
knows that.
whenever Honorable.
He has filed a can, Mr. Banerjee, that has not been served. He has
Oh.
filed a new.
Now it has been served on his advocate on this.
কি ফাইল করেছিস সেটা কি অ্যাপ্লিকেশন
Next Thursday আসতে বলছে।
Where he will come back.
No, but he has
But Milord, I do not think Milord, that is even to be looked into, because Milord, only on one point the writ petition was dismissed, which is now Milord well settled.
No, he says that he's going to rely on some new documents in Can 4.
Milord wants to consume some time, Milord, I will Milord accede to that. He'll just Milord delay my Milord relief,
The whole
nothing
purpose.
else.
And my lord, I have told my clients that whatever it
That
is,
you're going to-
niceties of law aside, you have to pay. In case you want to get any relief from this court, you'll have to pay
Too
the
late. at that
principal
time,
and the interest.
Too
My
late.
learned friend is only interested with his money,
No, Milord,
and I
I'm
can
interested in
understand
the
that.
property.
And I can.
He has
I'm
altered
interested in
his-
the property. I'm
There's
sure.
no.
He has altered his possession on the act of court.
Yes.
Made to suffer on that.
Yes.
Not act of court, act of bank. Court did
Must-
not allow
must-
him.
Court or tribunal.
It was. No. It was a bank sale.
Nothing pending
No,
in the
it was
DRT.
bank sale.
So what have you challenged in the 17th?
Lord, I've challenged the whole action of the bank taking possession and everything, my lord. Whatever
Whatever Milord, a
points are
dismissal
there.
order saying that Milord, the sale has been set aside and all this.
Sale has been set aside by the impugned
Which is
debtor.
under wrap.
Challenge the factum of borrowing of
Yes,
default.
yes. All that is there.
Only
But subsequent thereto, they have taken, bank has now taken possession also. All I'm saying is, my lord, a decision which is rendered as on a particular date as the law stands on that day cannot be recalled and or set aside on the basis of a decision 10 years hence.
Convinced
That's
of what
not
you're
the.
saying.
That's not the.
But, it depends on what the law, what the new decision is, what it says, whether it's prospective or
You're
retrospective.
convinced of what you're saying.
Milord, if my learned friend is
Again, I would
serious
like
on
to
this
argue.
point, Milord, I need to trouble
We
your
are only
lordship
here
with
to
one or two
argue, only to
decisions.
be rejected or accepted by this court. We are only here to argue.
No, this is a very recent Supreme Court judgment.
No, Milord, this started from 2013, Nobel Kumar, and then
No,
Milord up to
no, Not
2025.
that. My lord is, I believe, is
Recent Supreme
referring
what
to some.
you are arguing that. But
Yes.
The court said that all judgments will have retrospective effect
Unless
unless the new judgment says that it will be having
Yes.
prospective.
Yes.
That is also the last judgment. I
Yes.
think.
We've got
Then
Justice
we-
Oka, my lord, that's the
when
last
you
judgment.
leave aside the other documents, we take up the matter from
Huh.
there. If you have any such that no, that document must be looked into, then it is another
I
thing.
cannot possibly say that those documents are absolutely essential because this is one of the points. The other point, of
What
course,
are your
is
prayers in can for? What are you asking for? I mean, we are trying to understand the efficacy
Yes.
of the applications rather taking up the appeal itself.
Milord, I have asked for Milord to restore back possession,
In my
and Milord basically getting possession of the property
in my report,
and offering to pay.
So
And offering to pay.
new documents are not
No,
there.
Milord, some new documents are there with regard to the character of the property, because an additional point is that this property is a Milord agricultural property. Because cooperative society property, it is a cooperative society.
Agricultural property won't even come under the fold of the
Yes.
surface.
That's one of my challenges, my lord.
That's one of your grounds.
Yes, and my lord, more so, no documents are there of title for the bank to create a security interest. All these are there.
Milord,
Possibly, I may
if
win,
it's
I may
kind of
lose.
harvesting buildings, then Milord, this is agricultural property.
What is statement?
But, some points some documents I may show.
কিছু ফুটতে সাপ বের হয় না?
But the only crop, Milord, which can be found, Milord, in the property is a building.
I know, my lord. Agricultural land
Will be
itself is not a defense.
The application.
I've given.
With all annexures.
With all.
এই
Also, I'll also supply to the bank.
আমি কিছু জানি না স্যার।
আমিও কিছু
আমি
জানি না,
হচ্ছে
এর আগে।
ভুল বুঝিয়ে দিয়ে চলে যেতাম। ভুল বুঝিয়ে দিয়ে চলে যেতাম।
But, my lord, I've supplied to the bank also today.
Rupok, এত দুষ্টু
We
কি
are,
করে
we
হয়?
are dismissing can 2 as withdrawn. 1 and 3 are your applications.
One
Yes.
and three, my lord, friends application.
1, 2 and 3 are
One
mine.
is not
Oh,
1 and 3.
1 and 3. 1 and 3. I stand correct.
1 and 3 are what are
Milord,
the
1 is Milord for stay and 1 is Milord for condonation of delay. Possibly.
Condonation has to be allowed.
Condonation, no? Milord, I'll just check. Oh, 1 is for appropriate order, Milord, only to facilitate Milord the
there's no
hearing.
delay.
Now all the
Documents are there annexed.
are
Yes.
there.
Yes, everything is there. Everything is
No,
there.
no affidavits have been called for in the application.
Correct, correct. Whatever was before the Honorable Single Judge are all annexed, Milord, to my application. So, Milord, paper book
Applications
is
are
not
without
required.
any affidavits. Your lordship will take up the applications along with the main appeal.
Parties are okay. Push hearing for the borrower. Respondent number. The body is also there for the state. The body is also there for.
Yes. How are you? Fine.
After the injury I suffered,
Yes, yes.
I have become bit weak. I fall from the stair.
Yes, yes. How did
My lord, I was giving warning to my persons, those who are working inside home.
No,
Next.
better be careful, Mr. Dey.
There was water, and I fall like this. Two tendon has teared. It can't be repaired. The shoulder cannot be repaired.
Can't raise the hand too much.
Take care of yourself.
Shoulder cannot be replaced because of the age.
You are a young man, Mr.
76, what my lord is saying. I was young when your lordship was fighting with me in court. Deeply obliged.
What exactly ওটা হয়েছে? Tendency
ডাকো পরেরটা।
যথেষ্ট
Yes. ওর কি পচা মামলা নিয়ে এসেছে।
Well, this is that matter. It's all started in 2007. Lordship, imagine.
Faithful is the right word, I think.
আচ্ছা,
Before my lords proceed further, my lord, there is a review application, my lord, which is not coming.
No, that is, you have to take steps for reconstruction. That is what we told on the last occasion. Our officers, they informed me that they have also made a search for that review application, but that is not available. Then either you reconstruct,
We need to do
but the
that.
matter is getting adjourned. No? What is the, if you have a copy, you reaffirm it.
Even
I
we
have a copy.
We have a
Even
copy.
they have a copy. I have a copy. I will give it to them, my lord. I will reconstruct. I'll give it to your lordships. I have given them twice.
How
I will
can
give
you
them.
reconstruct? It has to be their client. No? They have to reaffirm and come there.
No, my lord, what I am respectfully submitting, but there's no dispute on the fact that they have filed a review application after the dismissal of the special petition. Appeal, which is the reported judgment of the division bench of this honorable court in jui finalis, if your lordship recalls, which we always refer to in resumption proceedings under section 6(3). Saregama Star Ironworks jui finalis, this is that same matter. So the division bench judgment was challenged before the Supreme Court, special petition dismissed. Thereafter, they come and file a review application. So that review application has never seen the light of the day. And my contempt application is pending, which is only restricted to, my lord, only one direction, that mutate my name in the land records. From 2007, I have purchased the land in a court auction. I have not been able to utilize the land. Why? Because my name is not in the municipal records. So I cannot deal with it. I cannot.
Why two review applications? Why two review applications?
Two writ petitions, two review applications, that's why.
So we do one thing. One review is already on record. So pertaining to that review, we can hear and dispose of.
My lord.
And as regards the other writ petition, that will be guided by the order which we have passed.
My lord.
And we will record that review filed, etc., reconstructed, and we will take that on record.
Well,
And it's
Start. ওই রিভিউটা কোথায় গো?
এটা দেবো, আমারটা দিয়ে দিই।
দুটো রিভিউর এক there is none of the reviews are here.
Neither of the reviews are. Both will have to be reconstructed, or at least one.
Yes, well, both. My lord, I have one in my hand, the other I have seen in my learned friend's brief. So both put together, we have both the reviews. So allow us to reconstruct both the reviews. And my lord,
Now, what order we will pass that you reconstruct? You have to approach the register, na?
My lord, kindly direct me.
To reconstruct the department.
আরে সই তো ওকে করতে হবে, ওর রিভিউ তো আমি সই করতে পারবো না।
সেটা দিয়ে দাও তাহলে আমাদের appellate side rules এ কোনো বার আছে?
No, there is no
For
bar.
the reconstruction, like
Yes,
the original side.
that record is
what has
not
to
on
pass
record, my lord,
the
before the High Court.
leave is granted for the advocate on record to reconstruct the brief. But we are not sure whether on the appellate side there is any such leave required.
Oh.
My lord, only one subject to correction, my lord. The reconstruction leave if granted, my lord, the documents which has been exchanged by the parties are reconstructed. Subsequent verification or affirmation of affidavit is not required, subject to correction. That may not be required. So, my lord, I have the review application filed by them. He also has it with them. So, my lord, if your lordship gives us the liberty, we will reconstruct it on their behalf.
Mr. Bose, ask your advocate
My
on
lord.
record, and you ask your both of you go to the register in the department, and if it is a requirement that we need to give you a leave, then we will keep it in the list and give the leave.
And my lord, without leave, they will not reconstruct.
No,
That leave is
appellate
required.
side, it is mentioned before the register for reconstruction.
No, my lord, your lordship kindly gives us the leave, considering that, my lord, the matter is pending for about just this review is pending for in excess of 8 years.
So, Mr.
কিছুই হয়নি। হ্যাঁ, এটা তো আমার কোথাও এখানে
Is leave
Manar,
required on the appellate side?
I need to check, Manar, before,
You ought to have checked matter is কবে থেকে পড়ে রয়েছে।
kindly keep it on Monday. Sorry, Manar, Tuesday.
তোমরা কি জানো? Leave দিয়ে দিতে।
Yes.
So give us those
Fine,
copies.
fine. This is one, this is RV 166, 165 টা এটা দাও। By chance যদি না দাও ভয় লাগে।
I'm not that dodgy. That I will not keep it.
8 years, তারপরেও how do you even suggest that you are not?
We have served the copy. That's how you got it.
So grateful.
সেটার জন্যই তো এদেরকে রেজিস্ট্রারকে বলতে হয়। এবার আমরা একটা অর্ডার দেবো, সেটা ইমপ্লিমেন্ট এটা লেখো, it has been submitted by the learned advocates
This,
It will not go out, Mr.
No,
Bose. It is assigned to us.
yes, my lord, your lordship
So-
has already directed the matter to go out. My lord, kindly
Sure.
direct the matter to appear any day convenient to your lordship. So that, my lord, this exercise is completed.
Send down the file, na? This is
Your
the-
lordship sends it down and, my lord,
No?
makes it returnable any day convenient. 1 week, 2 weeks.
Acha, this the matter for further consideration.
আমি তো কালকে হলে আরো better,
Hmm.
Monday হলে আরো better.
This the matter for 25 তারিখ তো আজকে
চাইছি
কত
Monday
18
যেন।
তারিখ 25 করে দাও।
Great.
In the meantime, you text us.
Great. ও তো তুলে গেছে আজকে।
Milord, my clients have an unreasonable apprehension that Milord, they may not be hard. Milord, there is no reason, Milord, for this apprehension. But since Milord, they are apprehensive of this, Milord, in this matter, Milord, I just indicate for their satisfaction that Milord, I am appearing in item numbers 18 and 51. Milord, 51 Milord pertains to Milord para-teachers. 18 Milord is a heterogeneous group where Milord para-teachers are there, other candidates are also there. My Lord, will kindly allow me, Milord, after my learned senior friends, Milord, conclude the submission, half an hour time, Milord, to trouble your lordships. Grateful, your lordships. Great.
আমাদের সমস্যা আইনি আর কিছু নেই।
হচ্ছে theory মানে বলে দিতে পারি আমরা। আচ্ছা আরম্ভ তো করুন। হ্যাঁ, because the recruitment নিশ্চয়ই।
এরপর কি অব্র বলবি? অব্র তো বলো এটা আজকে কাগজ
You are for the which appellants?
I am appearing for meeting number 1542 of 2023.
MAT
1542 of 2023.
1542.
1542 of 2023.
Yes.
Item number 34 or 2 pages.
Yes.
Now, my lord, at the outset, my lord, I should submit to my lord that
Yeah.
I am appearing.
এটা 873 ফাইলটা বের করে রাখ। ওটা আমার। Yes, we would suggest that if you can documents, if you can refer from 873,
No,
becomes a bit easier. Yes. Yes.
now, my lord, first of all, your
How
lordship.
many appellants?
That's what I'm indicating. That, my lord, I am appearing on behalf of 113 appellants.
113.
113.
You preferred leave to appeal.
Yes.
When was your leave to appeal allowed?
My lord, my leave to appeal was allowed on, my lord, 6/9/2023. And the delay of, my lord, 61
Allowed
days.
on
6th of September 2023.
Who are the honorable judges? Justice Talukdar and another?
No, my lord, Mr. Justice Shomen Chen and my lord, Mr. Justice, my lord, this is in volume 2 of my paper book. Just 1 second, my lord.
All right. Presided over by Justice Chen.
Yes.
All right. Then now you proceed. Yes. What is your argument?
Now, my lord, first of all, my lord, I would be submitting to my lords that, my lord, an appointment notification specifying the vacancies district-wise that was published on 26/9/2016. That your lordships, my lord, had taken, my lord, had taken into consideration on the last occasion. I have 26/9/2016 কোথায় সেটা? 26/9/2013 এইখানেই আছে তো। আমাকে বের করে দে। 26/9/2016 এর appointment notification. This is not a notification, sir. This is rules.
Yes. That is page 120 in 870.
Yes.
You are placing that?
No, yes, I am placing only, Miller, to take into consideration two things. First of all, Miller, your lordship may kindly consider
This is of 29th,
26/9/2016.
25th.
26/9/2016. This is the appointment notification for primary teachers.
Yes.
Now, Millard, Millard, permit me, Millard, to read this because this is something which is very important. In continuation to our notice dated 24/9/26.
This we cannot read. We have to.
I know that. I know that. That's the reason, Millard, I have brought, Millard, a better copy.
Mr.
Yes.
বিশ্বাস, it is in your compilation.
Millard, and yeah, it's not required, Millard. I'm just handing it over. ওটা একই জিনিস আমি ওটা ইয়ে করে দিলাম a bigger thing, otherwise it's not possible to do.
Compilation ওই যে একটা দেখো ওই একটা compilation দিয়েছে ইয়ে
On the last occasion, Mr. Dhar had also submitted this.
জায়গায় রাখলে Yes, that is it.
That is it.
Yeah, that is. Which was your appeal, Mr. Dhar?
I used the same.
Mat number.
Not in mine. I have even
mat number
This is not in mat number. That is in the.
I know it is not in my, but it has been tied together.
I'm giving.
132.
Malad not required. I'm just giving one page jumbo xerox. That will be malad.
দেখো এইখানটা আমার যেটা
Your lordship kindly malad.
Just sort out. Just let me sort out. যেটা 132 সাথে কার্তিক যেটা কাগজের সেট এসছে ওটাতে দেখো ওই ও জাম্বো জেরক্স একটা রিলাই করেছে আমি ওখানে রেখেছি
লেখাটা পড়া যায়
হ্যাঁ এটাই আরেকটা কপি মাই লটের ঠিক আছে একটা কপি নে এটা তুমি নাও এই যে yes
why I am submitting, Millard, my lords may kindly consider that, Millard, in continuation to our notice dated such and such, this is to notify to all concerned that online applications are invited for TET 2014 qualified candidates of West Bengal seeking appointment to the post of assistant teacher of a particular council only in the government aided sponsored primary junior basic schools under the district primary school council primary council to fill up 42,949 vacancies as mentioned below. The selection and appointment of the candidates will be made in terms of the West Bengal Primary School Teachers Recruitment Rules 2016 as amended up to date, notified number such and such, dated 2/3/2016. Therefore, Millard, in the advertisement, this was a specific indication that the recruitment rules of 2016 as amended, that has to be followed. Now, Millard, your lordship may kindly come to, because I told your lordship that I will not be taking much of time. Now, Millard, I skip over this thing, scale of pay, qualification, note, I skip, then kindly come to paragraph 5, procedure of selection, which has become now a subject matter of dispute.
Yes.
Now, kindly see, Millard, this paragraph I should place before my lords. The selection committee, after prima facie scrutiny of the duly filled application forms submitted, the candidates having requisite qualification shall notify the date, time, and place for scrutiny or verification of the testimonials of the applicants, those who have duly filled in online application for appointment. Thereafter, the selection shall notify the date, time, place for, Millard, kindly consider this, vivavocy, stroke interview, and aptitude test of all candidates. This I want to draw to my lord's kind attention. My lords is well aware of, Millard, that your lordships have laid down the law. Millard, in one of my matters also, your lordship had indicated that the terms and conditions indicated in an advertisement If on the basis of the terms and conditions a particular candidate appears in a selection, his right stands crystallized on the basis of the terms and conditions of the advertisement and the rules. Because Milord, two things have been indicated that in terms of the particular primary school teachers, these recruitment rules of 2016 as amended, as well as Milord, the particular Milord specification that the selection committee shall notify the date, time and place for vivabocy, stroke interview and aptitude test of all candidates.
Yes.
Now your lordship may kindly consider that Milord, then Milord, the performance of the candidates who will be called for vivabocy and aptitude test shall be assessed by the interview board, formed for the specific purpose. Thereafter, academic qualification, training, performance in teachers eligibility test, extracurricular activities, vivabocy or interview, and aptitude test or teaching experience in para 2 shall be computed in the following manner. This has been specified. The marks for the particular Milord, the process of the selection, that has been clearly indicated. Now, Milord, I submit, Milord, that there is, I find, subject to correction, Milord, permit me, Milord, to give a reply, Milord, if the occasion so arises. But with regard to apportionment of marks, I do not find there is any dispute so far as the submissions, Milord, which have been advanced by the learned counsels in respect of the batch of the matters, Milord, appearing for my lord's kind consideration. Then, Milord, I will be drawing to my lord's kind attention, Milord, about the provisions of.
No, what you are hinting at?
Milord, I am hinting at that, Milord, there was a dispute as to how the mode in which the aptitude test has to be conducted. This, what I can understand, it is for my lord's kind consideration. I do not say anything. Now, your lordships have already taken note of Rule 2C. Now, Milord, at only this cost of repetition, I say that I find that an aptitude means a test to assess natural teaching ability of a candidate, but nothing has been specified otherwise in the particular recruitment rules, nor in the particular Milord amendments. Now, Milord, I found out a judgment of the Supreme Court.
That day, Mr. Dhod argued that we asked him,
yes,
that we clause 545, whether any modality or procedure or guideline of the council did set up the board.
Yes.
Paragraph Rule 4, Sub Rule 5.
Yes.
That with the prior approval, board shall have the
following powers to lay down the modalities, procedure or guidelines.
So there was no such procedure.
Yes.
So what you are trying to show us? What is your
Now, Milord,
other portion you will show us from the notification, 26 September?
No, I do not want to.
You have only said that it will be guided by this recruitment rule with the amendment, and the selection committee is to notify the date and time of the aptitude test.
Right. And this thing has to be taken together. What I mean to say that, Milord, there is.
Then what is your point? What is
my point is that, Milord, so far the particular vivabocy test is concerned.
No vivabocy, interview aptitude.
I say, Milord, that this aptitude test, which was taken in respect of all candidates for the district of Uttar Dinajpur.
What?
In respect of all candidates of the district of Uttar Dinajpur, there was holding of aptitude test. But I should show only one thing to my lords, that, Milord, in the judgment, Milord, which is the subject
was held. Aptitude test, no separate date was fixed.
No, I say I only
along with the interview.
No, I say, why I say this.
You are from Uttar Dinajpur.
I am appearing only for the district of Uttar Dinajpur. Now, kindly consider.
Just a moment.
Milord, I'm sorry, Milord.
Yes.
Now, my lord, sorry.
Except the definition. Yes.
Now, my lord, your lordship may kindly consider that in the judgment under appeal.
No, we didn't understand what is the point you are arguing.
My lord, the point which I am arguing is in respect of the aptitude test.
Yes. What is your content?
My point is that so far as the particular candidates are concerned, from the district of Uttar Dinajpur, there was holding of aptitude test.
Where the holding were you notified? Were you notified?
We have been given a particular letter indicating that, just like Millard, what has been mentioned in the particular Millard, this appointment notification.
To show us that you were
That's the
notified.
reason that's the reason I told you, Lordship Miller, that this particular notification of the particular Vivabosi interview and aptitude test, this was given in one single letter.
To show us that, is that the letter there in your paper book?
No, that letter is not there in the paper.
So your contention is there was a communication.
Yes.
The interview and aptitude was held on the same date, same sitting.
Yes, and now Millard, kindly consider the particular Millard para 9 of the judgment at my paper book, page 147.
Aptitude হয়েছে। Yes, what you are saying?
Miller, I am just drawing to my lord's kind attention to page 147 of my appeal, Miller. I do not
tell us the internal page of the judgment you are placing.
Yes, the internal page is Miller. It starts page 5 and 6. Page 5 and 6.
You বের করে দাও সাহেব।
16 or 170. Mat 870 610. Mat 870 610 page. Judgment to?
হ্যাঁ, আমি ওটা internal page ধরে বলছি।
আমি তো বললাম 116 বা 6 first. No, 610.
Yes, judge places 1, 5 and 6. What you want to show?
Now, Miller, kindly see page internal page 5. In respect of holding the aptitude test, the president of the board in his report said that aptitude tests were taken, but from the evidence adduced by the interviewers and the candidates, it has been proved before this court that no aptitude test was taken. In this regard, the order passed by this court in this matter on 6/2/2023 is required to be quoted. This order was quoted. Now, Miller, the most important thing is kindly come to the next page, internal page 6.
Yes, we are there.
Yes. Now, kindly come to Miller, serial number. I am just indicating to the serial number, Miller. Kindly do keep a Miller, because since I am only restricting my submissions, Miller. Yes. Serial number 2. 2.
Serial number 2.
Yes, this is from district Uttar Dinajpur.
So you, in respect of all the candidates from Uttar Dinajpur, they have said aptitude test taken.
Yes.
This is your argument.
They have appeared in the particular aptitude test.
That
now,
is serial number 2, 5.
No, not 5.
2, 6.
2, 6, 10, 14, 18, 22, 25 and 29. Now the most interesting part is 25.
Except 25, all said
aptitude test was taken.
And he said does not know what
is aptitude test. Now also kindly consider this observation at page 8 of this internal page 8 of the judgment. No question asked by the appearing parties to the above interviewers. The evidence is recorded and are kept on record. Miller,
where you
Miller, I am reading to page 8, internal page
Yes,
8, which
yes.
your lordships have noted, my lord, there is an observation. No question asked by the appearing parties to the above interviewers. The evidence recorded are kept on record. Now, if your lordship, my lord, asked me, my lord, I found, my lord, in the judgment, in the paper book, my lord, filed by the board. In the paper book filed by the board, your lordships may kindly take into consideration. My lord, just 1 second, my lord. Yes. My lord, there is, my lord, a submission. My lord, not submission. My lord, one Shankar Thapa, although he did not give evidence when he was one Shankar Thapa, I find, my lord, that when he was called upon by the court to give evidence, and this he did not turn up, and such fact would be evident from the order dated 24/1/2023. My lords have was given a bunch of the orders, 24/1/2023. একটা দিলেই হবে। Kindly see internal page 2. Though the name of one Shankar Thapa representing I'm sorry, Millard. I'm sorry. Millard, should I hand over
24, no. 24?
24 to 24/1/2023. I'm sorry. 24th of January 2023. It is Millard, possibly in page
423.
Yes.
volume 2, page.
Yes, tell us.
Millard, kindly see the third paragraph. Though the name of one Shankar Thapa representing Uttar Dinajpur was mentioned in the list handed over to me by the petitioners, Mr. Thapa is not present, and I have taken evidence of 19 candidates exercising my power under Section 165 of the Indian Evidence Act.
So Thapa was not present.
Not
He
present.
was an interviewer of Uttar Dinajpur.
I'm grateful to my lords. Now, the part.
So, in such conspectus of facts, the court couldn't have observed that no aptitude test was held. That is your argument.
I submit that so far as the district of Uttar Dinajpur is concerned, the aptitude test was taken in respect of all candidates. This is my first submission.
So you are negating the contention of the judge in paragraph 9 of the judgment where he says that.
Yes. I'm grateful to my lords. I'm grateful. Achha. Dara.
So, Mr. Bhattacharya, your clients are working teachers, na?
Yes, working.
Today is a Friday. What are they doing here? Don't they have schools? They are duty bound to teach the students. What are they doing here? Watching the fun. 8 days we have heard, and all of them are present on 8 days in all the schools.
They could not be present. They were looking into the online. The particular thing, Millard.
No, your teachers are now enjoying an interim protection. They are working,
Yes.
na?
Yes.
So why they are here? They are not teaching the students?
Millard,
not required.
No,
That
no,
is
no.
secondary. First is whether we will lose our job or not. And they don't understand also. We will get appointed, get our money, salary finished. We will go and watch the drama in High Court. We will not work in schools. Your clients are here from Uttar Dinajpur.
No, not all. Millard, they two or three.
You do not require their assistance. You have called them and had a
Yes,
conference
yes.
in the chamber. So for what they are here? Students of West Bengal are suffering, primary school teachers. Whether our jobs will go or not. Today we will not pass an order whether your jobs will go or not. Don't be worried. Attend your duties. You have went to Supreme Court and obtained an interim order. Yes.
Now, my lord,
Yes, you have shown us third paragraph of.
yes. Now, my lord, I will be submitting to my lords that.
Sorry, we disturbed your.
No, my lord. Your lordship had expressed, and this is one thing, my lord, I should say out of my own volition, that in many courts it happened that when I was appearing in the education matter, my lord, the honorable judges were telling me that show me one school in West Bengal which has no litigation. And your lordship is more experienced than me
No, so
insofar as the
teachers
education
will be
matters
there
are
in High Court.
concerned.
They are not required in the schools now. Some sort of sincerity in your
Lord,
job.
I have no words to say. I cannot
see the state of affairs. You are
I say I have no words. I cannot make submissions.
Today, if I haul any one of them up, they won't be able to justify their absence in school. But they must have put in an application in the school for a casual leave. Check it up. If we desire, we can initiate disciplinary proceeding against these persons. Sir, what they will understand in court, you will make your submissions. Unfortunate state of affairs. Yes, tell us what.
Now, my lord, I submit to my lord's my lord. I had, after my lord looking into the nature of the submissions, after hearing the
Summarized your argument. Your first argument is recruitment rules cannot be deviated from. It has to be on the basis of 2nd March and the subsequent amendment.
Right.
And a perusal of the rule will say that there is no separate guideline for holding aptitude in any other date. It is coupled with interview, and on the respective dates, aptitude was state. The formation of opinion of the judge on the basis of the evidence taken in course of 165, majority of the persons from Uttar Dinajpur have said aptitude test held. And Sham and Thapa, who was the interviewer pertaining to Uttar Dinajpur, was not there.
Now, Millard, no, Millard, just.
Yes.
I found out a judgment. Kindly excuse me, Millard, if there is any fault on my part. That.
You expect us to excuse before we see?
No,
we will decide whether we will excuse or not.
Kindly see the judgment your lordship is perusing, Millard. 2004, volume 6, SCC, 218, paragraph 6. Millard, I say that in absence of a specification as to how aptitude test has to be conducted, the appointments which were given, they cannot be said to be unorganized. Paragraph 6.
Yes, Mr. Yes.
Now, my lord, the next point which I will be urging before my lords, that my lord kindly for a second, my lord, peruse the particular provisions of Rule 5, Rule 8, Sub-Rule 5B, 1, 2, and 3. This, my lord,
Yes. Rule 5. We are on Rule 5. Yes.
Rule 8, Sub-Rule 5.
Yes, Rule 8.
Rule 8, Sub-Rule 5, B1. 1, 2, 3, 4.
Note 4.
No,
Sub-Rule 5.
Rule 8, Sub-Rule 5.
Huh.
Then Miller B.
Yes.
Then small Roman 1, 2, 3, 4.
Hmm.
Why I want to show? Because this particular selection, Miller has to be made in every district. This has to be made district wise. Now,
selection committee shall prepare separate council-wise panels.
Yes, and a panel of all selected candidates in a district. Has my lord got it, my lord? Rule 8, 5B1. A panel of all selected candidates.
Yes. In a district.
In a district. Then, my lord, the categories have been mentioned, and that will be made serially.
So every district is under every district council. There are
Yes,
1 to 1.
Yes, I have checked up meticulously.
There is no council having control of.
I'm grateful. I'm grateful. Now, one significant feature, because other way around, your lordship may ask me, this I was also, it came to my mind that supposing if your lordship asked me that why are you showing me this provision? My lord, I go to an extreme stage. Then, my lord, I found out that in the writ petition which was filed by the persons, my lord, that is this PRIYANKA NASKAR, there, my lord, there was clubbing up of all districts. On that score, whether your lordships will be entertaining the writ petition. The entertainability of the writ petition, not the maintainability.
Yes.
Now, and none of the district councils, my lord, have been made parties in the writ petition.
One district council may.
Is there. Now, your lordships may kindly consider also.
Yes.
My lord, I go to, because I think that it would not be proper on my part to make repetitions. I had heard the extensively, my lord, the proceedings before my lords. Now, one thing which I will be showing to my lords, that I have read the judgment number of times, the judgment under appeal. Well, I do not want to name the honorable judge, but my lord, the judgment under appeal. Now, my lord, I do not find that there is a specific material on record or any tangible evidence to suggest that a corruption was committed.
Yes.
And my lord, my lords have laid down the law that there has to be a proof of guilt.
Yes. All right.
Then, my lord, I submit to my lords that from paragraphs, my lord, of the judgment, my lord, accepting the observation part, because why? When my lords are giving the judgment, my lord, lordship is quoting on down the submissions of the learned advocates, then your lordships are giving some observations, and then after that, my lord, the conclusions and what has to be done.
No, that is varies
Now,
from judges to judge. That varies from judge.
Yes, and there is no prescribe. I also found, my lord, I had a book, my lord, this was given to me by my senior, how to write a judgment. No, my lord,
What is it, G?
my lord, I say, my lord, kindly do not embarrass me.
Doesn't have to write a judgment. Why did
Lord,
you go to
kindly-
that book?
kindly do not embarrass me, my lord.
We have embarrassed you. We don't, so much of courage we have to embarrass the advocates.
Kindly, I appeal to my lords, my lord.
Yes, sir. What are the rules you, further rule you want to show?
Yes, my lord, now your lordships may kindly also consider that one thing I should say to my lords, my lord, that we are all untrained candidates at the time when the selection process was started in 2016, but subsequently we had acquired training qualification in 2019. This thing also I should, my lord, draw
all your appellants.
All. These I should
that
not.
Mr. Pratik Dhar has argued.
I say, my lord, I do not want to. I am
that
just.
I am a class apart now.
Yes.
You cannot treat me as an untrained now. I am in service. I have completed training. I am a teacher.
Means class within a class. This.
I think if we have appreciated Mr. Dhar's argument, his contention was, is it not, Mr. Dhar? That was your argument.
Exactly.
Yes. So you are adopting
I'm
such.
just adopting the I am adopting the submissions, my lord.
So all of you have completed training by now.
Yes. At least so far as the district of Uttar Dinajpur is concerned, my lord, I cannot say others because that will be a far-reaching consequence.
They must have.
Must have.
Otherwise, they would.
Must have.
Yes.
Now, with regard to the extensive submissions made under section 165, I do not want to add any word, but I say that only one thing I add, that I have checked up the old judgments which were prevailing in the field. Now, I cannot make a watertight compartment that evidence act can be exercised by the judge under Article 226, nor I can say that it cannot be done. This, my lord, I am submitting. Yes. This I should say, my lord, as an officer of the court, I cannot make a watertight compartment. Now, your lordships may kindly consider now, my lord, your lordships may kindly consider, your lordship was asking, my lord, the revert senior, my lord,
Sir, each of the sub-clauses starts a panel of selected candidates.
Yes.
And there was no publication of panel.
I am coming to that point. I have made my note. I am coming to that. Now, before I come to the question of the panel, I very respectfully submit to my lords that the, Millard, subject to correction of my lords, kindly do not take me amiss. Your lordship is more experienced in these particular primary and secondary matters. There is no provision in the West Bengal Primary School Teachers Recruitment Rules of 2016 for publication of panel in the public domain. There is no provision for publication of panel in the public domain.
Then why in the definition of panel it is given so?
Definition of panel is given, but kindly see whether
by the board.
Kindly see, I say, Milord, with the deepest of respect, panel means a list of names of the eligible and selected candidates for appointment as teacher in primary schools published by the board according to the rules. Therefore, after this entire selection process is conducted in terms of Rule 8(5), then, Milord, I find in the...
No, just imagine a situation. I am a participant. I give my exam. After exam, I am not getting my result. Suddenly, one fine morning, I get an appointment letter. So then, first of all, I should go and find out that whether there was... I mean, I don't know, that will be maybe their argument.
Yes,
yes. If there is no publication of the panel,
how do I come to know?
Then the entire gamut raises suspicious circumstances.
Yes. Now, Milord, your lordships may kindly consider that so far as the selection procedure of the particular statutory bodies or other bodies are concerned, in most of the cases I found.
No, that cannot be a justification.
No, I cannot. I am not saying that your lordship, I am not saying that one illegality.
No, we have in primary matter we have seen court has directed that if board has said high court matter pending. I will not
your lordships may even, at the risk of repetition, I am submitting that after this particular 8(5), as your lordships have taken note of it, there is a particular Rule 9 which says approval of the panels.
That is
therefore,
why
yes. Therefore, this is pre-publication. Then, Milord, comes the stage of the appointment letters, issuance of appointment letters. Yes.
Now, then what is your argument? It was published.
Milord, I say, I have on behalf of District Uttar Dinajpur, I say that in the office of the District Primary School Council, Uttar Dinajpur, there was pasting of.
Where is that paragraph in your leave to appeal? There was a pasting of the panel. Show us.
No, I say, Milord, I submit, Milord, what has happened, I can say to my lords.
No, that has to be your averment.
Milord,
consider one argument of yours that should be supported by an averment. Because you have taken a point that no averment made in the petition.
I say, Milord, at that stage.
So can we record that it is your upon instruction your submit?
I am upon
panel was
upon instructions. This much your lordship can record, but I cannot say, Milord, that I cannot say that this has been pleaded. This has been pleaded in the particular the stay application. I cannot say that.
Then it becomes a very anomalous situation.
Yes. Now your lordships may kindly consider also that, Milord, even if your lordships, Milord, then Milord comes to after this Rule 10, if your lordship comes to Rule 11, 12, 13. About publication of panel in the public domain, I do not find, Millard, this is an inference, or Millard, this can be at best an expression of the court that when a person appears in an examination, he has a right to know. Now, today, Millard, what is happening is that when a person is appearing in an examination and he is not getting any information, he is making a letter to the authorities in terms of the Right to Information Act. Kindly supply me the marks secured by me and the last cut-off marks.
Which has been subsequently done. Your Uttar Dinajpur marks were disclosed, no?
Yes,
The
that's
website.
it. Pasting. That's the reason I say, Miller, or this is on
No,
instruction.
during pendency of the writ petition,
not
pendency of the writ, board has uploaded information, no?
Miller, this is for
before. There are so many writ petitions filed at the relevant time, challenging the panel that was published by the board. Annexing the panel. Annexing the panel.
No,
So many
Mr.
writ
Gupta, was there publication of
Yes,
panel?
publication of the panel in each office of the district primary school council.
No, never.
So that must be under a signature of an officer.
These panels were annexed with the writ petitions, so many writ petitions.
Maybe leaving aside that,
Numbers.
no, leaving aside what you are the statutory body.
Yes, it
So,
was published that.
did you have any decision for publication of panel? Board must be, no group D staff can go and just paste it. There must be a system, no?
Some letter sending issued by the board to the respective DPSCs to hang it up.
That letter has been brought on record.
I haven't seen that letter, but the panels, Millard, in different districts have been annexed with the writ petitions where they have challenged the appointment. There are so many writ petitions.
No, we want to know what was the procedure adopted by you. After written test, interview, aptitude.
After everything, Millard, the panels were the respective panels of each separate district were sent to the respective DPSCs for hanging up in their notice.
After approval by the board, now first it has to be sent to the board.
After every stage is over. It was just sent to the DPSCs for the purpose of issuing appointment letters on the basis of such panel.
But that is not stated in your affidavit in opposition.
Millard, this question was not raised perhaps.
Yes.
In any event,
of course raised.
I can produce, Millard, several writ petitions before your lordships filed by the respective candidates.
Maybe in support
annexing those panels.
But you have not made any amendment to that effect in your opposition. This what you are submitting, subject to correction. I may be wrong.
Maybe, but if I can demonstrate before
Mr. Gupta, please check up this point because I think Mr. Bhattacharya and others will be
definitely
pointing out the infirmities so that you can assist the court to that effect. Yes, Mr. Bhattacharya, finished?
Yes. Now the last thing which I'm indicating now, Miller, kindly also see Rule 9.
Rule 9. Yes.
Approval of the panel.
Yes.
The panels after being prepared shall be accorded approval by the board and thereafter shall be sent to the respective district primary school council with necessary papers for appointment. Therefore, this is the stage, Millard, which my learned revered senior Millard was indicating that it was done by the particular Millard respective district primary school council.
Appointment or teacher published by the board according to
ওইখানেই তো গন্ডগোলটা তুলে রেখেছে তোদের কে বলতে বলেছিল এইটা অ্যাড করতে
published by the board.
Now you see rule 9 my brother points out.
Yes.
Rule 9 and the definition if you read together rule 9 says the panel after being prepared shall be accorded approval by the board. Let us stop here.
Yes.
Now kindly come to the definition.
Definition.
Panel means a list of names of allegiance here as teacher
published by the
board. So this definition clause does not fit in rule 9.
No, there is an indication after it is approved by the board,
Yes, but
then it
now
will be
there
sent
is
to the
no-
district,
No, there is no statement as regards publication by board.
Milord, my
That
lords,
board will approve and publish it.
I say, Milord, my lords have laid down the law that
No, how we can interpret, but we cannot subtract something from
no, nothing, not at all, because these rules are handmade for justice.
Right. So we have this rule 9 and rule the definition subject to what you say may be incompatible. Maybe. All right, Mr. Bhattacharya.
Yes, and last definition I give, and then I close it.
Which definition?
Now, what is the definition of corruption? Because your lordship had indicated,
That
because
Mr. Dotto has argued.
Milord, I know that Mr. Dotto will be arguing that, but I got a judgment.
What is your argument as regards corruption?
Milord, I say, Milord, there was no corruption. Why I say because why I say I have to go by, Milord, the particular wordings of the Supreme Court. It is easy to say that there was there was commission of corruption, but it is very difficult to prove it. Unless it is proved to the Milord, to the hilt, it cannot be said that there is a corruption. There is nepotism. Milord, kindly, Milord, I'm just having. Milord, 2007, Volume 7 SCC 358, paragraph 3, it deals with definition of corruption.
Paragraph 3.
Yes. कोई जजमेंट पे करेगा कोई जगह बस
Yes. Yes, Mr. Bhattacharya.
Milord, it has been indicated, Milord, kindly see the definition that corruption as such has reached dangerous heights and dangerous potentialities. The word corruption has wide connotation and embraces almost all spheres of our day-to-day life the world over. In a limited sense, it connotes allowing decisions and actions of a person to be influenced not by the rights or wrongs of a cause, but by the prospects of monetary gains or other selfish consideration. Avarice is a common frailty of mankind, and while Robert Walpole's observation that every man has a price may be a little generalized, yet cannot be gainsaid that it is not far from truth. Bach cautioned, among a people generally corrupt, liberty cannot last long. This has been the definition. It is not my own, Milord, perception or my particular, Milord.
So how do you say your case does not come within paragraph?
I say why I say this thing. Kindly consider.
Let us go line by line.
Yes.
Corruption as such has reached dangerous heights and dangerous potentials. Do you deny?
Right.
You cannot deny.
No, I say here the Supreme Court is saying, as I told you, Milord, I will be showing another judgment.
No, another judgment will go. You explain this paragraph.
Why? Because corruption, if your lordship has to take, it has a wide connotation and embraces almost all spheres of our day-to-day life.
Right.
Now, supposing today, if your lordship, Milord, is of an opinion that, Milord, there has been corruption so far the particular this particular, Milord, selection process is concerned. What is that factor or what is that clinching evidence by which it can be inferred? Milord, admittedly, I should say, as a matter of fact or as a matter of judgment, Milord, that insofar as the School Service Commission matters were concerned, there were ample documents on record to suggest that This was the entire selection process. It cannot be say, rather I should say, Millard, that it cannot be said that it was faulty, but I say, Millard, there many illegalities had, Millard, crept in the selection process. But insofar as the present case is concerned, with my very little understanding, I do not find any matters on record by which, Millard, it can be inferred that there has been a corruption. And last judgment, I say, and then I conclude that, Millard, this is the government, Millard, the Supreme Court said how the government should tackle corruption. Millard, this is a judgment, Millard, kindly see, 2017, Volume 8 SCC 757. Paragraphs number 2, 54 to 58 and 61. And there the Supreme Court is even observing, Millard, in, I must say, Millard, in paragraph 61, I find that
paragraph 2. Which are the paragraphs you said?
Millard, I said, Millard, just 1 second, Millard. Millard, I only said paragraph 2, then paragraphs 54 to 58, 54 to 58, and 61. And kindly take note of 61.
ওদেরকে বলেছো অভিজিৎ আসার জন্য বলেছো?
The main, yes, Millard, the main reason of corruption now today, as it seems, Millard, this becomes, Millard, apart from the issue, that this is fall in moral value, because I am always deciding how much of wealth I should have at the cost of particular persons. And the Supreme Court is saying, Millard, kindly see these observations. I was also rather, Millard, very much, Millard, persuaded by this submission, by these, Millard, observations of the judgment. Tackling corruption is going to be a priority task for the government. The government has been taking constant efforts to deal with the problem of corruption. However, the constant legislative reforms and strict judicial actions have still not been able to completely uproot the deeply rooted evil of corruption. This is the area where the government needs to be seen taking unrelenting, stern, and uncompromising steps. Supreme Court observes that the government needs to be seen taking unrelenting, stern, and uncompromising steps. Leaders should think of, Millard, this is also, Millard, I should point out to my lords, leaders should think of introducing good and effective leadership at the helm of affairs. Only then benefits of liberalization and various programs, welfare schemes, and programs would reach the masses. Lack of awareness and supine attitude of the public has all along been found to be the advantage of the corrupt. Due to the uncontrolled spread of consumerism and fall in moral values, corruption recommending to the basic values of tradition rooted in ancient and external wisdom. Unless people rise against bribery and corruption, society can never be rid of this disease. The people can collectively put off this evil by resisting corruption by any person, howsoever high he or she may be. Here I say that, Millard, this is, if these be the observations of the Supreme Court, therefore, Millard, unless a particular, there is a general awareness of the people, Millard, your lordship cannot, because then every selection, I say, Millard,
is exactly what they are wanting to do.
Yes, I say,
they are wanting to do, people collectively these writ petitioners.
No, I say
put off this evil,
yes,
by resisting corruption
yes.
by any person, howsoever high he or she.
Therefore, my lord, as I showed and had told your lordships, that it is easy to allege, as if my lords have laid out the law, I must not get, it is alleged, it is easy to allege malafide.
It's a serious problem. It is a serious problem.
Very serious problem. And now, my lord, kindly consider that today, supposing, my lord, I go to an extreme submission, I go to an extreme case, that my lords is totally, my lord, cancelling the selection. Will your lordships, my lord, I am putting this question to this court, that will your lordships be able to, my lord, erode the corruptions? Never. I say, my lord, against that question.
There would be a fear.
That's right.
At
Never be big, and
as people will start fearing that let
no,
us
I
not
say,
get
my lord,
this sort of-
fear is always required. But, my lord, at the same time, a good morality is required in order to, my lord, erode these things. Otherwise, it cannot be done. Because your lordship, my lord, I fairly remember that, my lord, your lordship was indicating to Mr. Mitra that how to remove corruption. And why these persons will be made to suffer. And because, my lord, I am not citing those decisions. Your lordships have those decisions, but I have brought the decisions that appointment should not be disturbed. This is all, but I think, my lord, I should also add that this appointment should not be disturbed.
Mr. Bhattacharya, you
Yes.
answered you also say that there is corruption.
No, I do not say that. I do not say in the given case.
Sorry,
Not
you
at
said,
all.
You said, sorry, I correct myself. You
Yes.
said that in society there can be corruption.
Yes, yes.
You cannot totally eradicate it.
Not at all.
Why? Because it is the mind frame of the people.
That's right.
It is the mind frame of the people.
Yes.
I go to a place, I think
That by
if I
giving
can-
money or
that if I get- no,
I
if
try to
give-
purchase a person.
No. If I give 10 rupees, I can complete my work within 2 minutes.
Yes.
If I do not give 10 rupees, then
This
I
will not
cannot
be done.
So then who are responsible? The persons
persons
at the
who-
helm of affairs
Yes.
are responsible. So if the leader of the family says, give me some money, then I will do it for you. And if you fall a prey to that, you have to suffer the consequences.
No, I say that's a reason.
Ideally speaking, corruption, who is to be blamed? Government is to be blamed because
Yes.
they are conducting the selection
Yes.
process and dealing with fates of people who do not have the money to make their both ends meet. Now, if a person sitting at the helm of affairs says that yes, you give me something, I will arrange to do something. Suppose this
Just
is
like the
good,
concept
bad,
of quid pro
indifferent.
quo.
Good, bad, indifferent.
Just
Suppose
like the concept of quid pro quo.
now, his lordship says that prima facie you cannot rule out corruption. Why? Because there is CBI investigation. Your minister is in jail. Your persons on the helm of affairs have already been hauled up.
You know, there I
At
should-
this stage, you cannot eradicate this finding that
Yes.
there had been no corruption at all.
I only add one thing. I was also in this thing
So
exactly.
then how do the courts save the persons who have built up their families for 5 years having been employed?
Millard, I say, Millard, here I should be joining the issue.
We are wanting an answer on that.
That's
That is why we are eager to hear what they are wanting to say.
Right. Now, Millard, it is a well settled thing that which my lords have laid, that long standing, because these persons are working for a substantial time and
that is another aspect.
The appointment should not be disturbed.
That is balancing of equities. That
Yes,
will come later.
yes, yes.
But the thing is, you have to satisfy us that, sir, I am not responsible.
Millard, I
My
say,
friend might have given the money.
Millard, I only submit one thing, that there has to be some clinching evidence on record to establish that corruption has been done.
There are
present case.
There are, subject to your submissions, there are instances or evidences on record that there had been corruption.
Millard, your
question is, it has not attained finality.
Yes, and
Question
Millard,
is, it has not attained. It is under
citing
investigation.
the example of the of some honorable ministers. Millard, I do not name.
No,
now,
wanting an
has there
answer
been
to
a proof of guilt? Has there been, supposing today,
Except
Millard?
there has been no finding of guilt. We are
Yes,
saying so.
yes, there is no finding of guilt.
There is an investigation going on.
Yes, that is that is in a latent stage.
Right. So you
It is in a
satisfy-
latent stage.
So you satisfy us that this can happen in many cases.
Yes, yes, yes.
An investigation may be a fake investigation also.
Yes.
So maybe suppose for one moment we say that the investigation as it is seen will not ultimately succeed.
Yes.
And before it succeeds, you are killing me.
Therefore, Millard, what I was submitting, what I thought over the case, I leave it for my lord's kind consideration and what the other members of the bar will be indicating to my lords. But kindly think, this thing, that Millard, tangible evidence on record, but mere statements of any honorable judge, least to speak of, Millard, the order under appeal of the honorable judge who has, Millard, delivered the judgment. That has not been proved, which your lordship is indicating. And that is a sheet anchor of the matter. It is a sheet anchor of the matter. Yes, if there is a proof, then certainly, Millard, I should say that even then, if a person, Millard, makes submissions, he will be rather, Millard, making a misconduct on his part.
So suppose after investigation, guilt is established.
Yes.
You will come to High Court.
Yes.
Then you'll go to Supreme Court.
Yes.
In the process, 20 years will go.
Yes.
And your clients would be getting the benefit of 20 years.
They will be directed, my lord. The penal consequences will be
What
imposed
penal
upon the.
consequences? They will
Kindly
give
see,
themselves.
and the fallacy of the law. Fallacy of the law that cannot be cured.
All right. Thank you, Mr. Bhattacharya. Yes, who is next in line?
And my lord, so far the appointments should not be disturbed. I got 3 judgments. I am just giving the reference. I have my lord, 2009 volume. This is only how to balance equities.
2009 volume.
Volume 1, SCC.
Yes.
768.
Yes.
Paragraphs 53 and 54.
Yes, 53 and 54. Which is the other judgment?
53, 54. Then 2001, volume 3 SCC 328.
Yes.
Paragraphs 5 and 6. Then AIN 1998 Supreme Court 3268. Paragraph 3268.
Yes.
Paragraph 6.
These are on balancing of equities.
And the doctrine of comparative hardships.
Paragraph 6.
Paragraph
6 last time.
Ha. Therefore, my lord, having regard to the facts of the case, I very respectfully submit that, my lord, in respect of the candidates,
yes,
who are working, kindly consider that their appointment should not be disturbed.
Yes.
Your lordship may, my lord, even my lord, if your lordship may I go a stage further, your lordship may impose some conditions that if it is proved in future, insofar as the training qualification, or insofar as these particular teachers are concerned, that there has been a corruption, then certainly they can be put to task. Otherwise, what is the situation now, my lord, in the School Service Commission matters? The persons whose appointments have gone, my lord, they are committing suicide. They are doing something which cannot be, my lord, expressed in words. It is not a political jugglery. It is a matter wherein, my lord, the particular problems which has been emanated, that has to be solved. Court acts as a guardian. Court does not institute or does not aid of giving, my lord, protection to the political persons.
Yes, thank you.
I'm grateful to my lords. My lord, this is an extreme. My lord, only thing, if in reply something is required, kindly give me, my lord, some time.
Every day we are repeating.
No. I
want
am not.
to hear
I am
the
not. My lord, your lordship has
substantive.
given me enough
Right.
time.
Thank
What
you.
I, my lord,
Yes,
require.
Mr. Mojumdar, you are appearing for appellants in?
Yes, I am giving the details.
You are in appellants in?
An appellant in MAT number 1383 of 2023. The appeal was admitted on 6th
Yeah,
of...
only one you are appearing in
No,
one?
2 appeals, man.
Another one is?
Another one is, man, 1409 of 2023.
1409 of 23. Acha, in respect of 1383, petitioners are from which district?
Several districts.
Several districts. When was
the appeal was admitted on 6th of September 2023. Both the appeals, in fact.
And in the other
And I am
appeal,
representing in total about 1600 candidates who are working now.
all teachers, para
All
not.
teachers, no para teachers.
And in in MAT, there are how many applicants?
No, total.
Both the
In
appeals
one,
total?
in MAT 1409, to be precise, 669 candidates, and MAT 1383, 973 candidates. So it is in excess of, my lord, 1600.
In a one is 973. One is 973 and the other one is
973 in Math 1383 and 1409 it is 669.
Very good. Yes, yes.
My lord,
669 and 973. Yes.
May I start? My lord, I have read
একটু বের করে
in course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, when the stage of interview and aptitude test came, only interview was taken. My lord, we find, and it's a, in science we used to read mutation. This is again a sudden permanent change in the nature of litigation. What
No,
the
that was the case of the petitioner.
that
which
was the
is
case
not
of
a-
the petitioner, my lord.
Now here it starts in course of hearing a serious
That is what
allegation
I am submitting. So,
This
my
is
lord,
an
the case
allegation.
of the petitioner which was made out in the writ petition or canvassed before the honorable single judge as on 20th December 2022, my lord, it was their case that aptitude test was held as recorded by the honorable single judge. On 17 January 2023, my lord, then there is another recording which says that no aptitude test was held. Now, my lord, the honorable single judge decided to exercise my power under 165 of the Evidence Act and asked some questions after administering oath to 7 of such candidates.
Now, apropos this, what was the averment in the writ petition?
Regarding
This
aptitude test?
This contrary statement which you are showing us.
Nothing. There is no aptitude test, no averment.
So we are wanting.
Yes, absolutely, my lord. This is a very pertinent question.
So as per you, there was no averment that no aptitude was held.
Absolutely. We bow down to your lordship. Bow down to your lordship. Similarly, we find 7 petitioners were being picked up and they were asked to depose. My lord, I will be making a submission during the course of my hearing that this exercise, this inquisitorial exercise of under section 165 could not have been carried out in judicial review proceedings. And I would rely judgments rendered by the Honorable Supreme Court for that purpose. There is no dispute, there is no cavil to the proposition of law that section 165, just pausing here for a moment, section 165 is perhaps a statutory imprint, my lord, which basically embodies inquisitorial process in adversarial system. For that, my lord, I think, my lord, nobody would have any objection because that is the law. Now, my lord, kindly come to page 422. How the trouble started, my lord. From their evidence, this is the key factor in this matter. This is on 17th of January 2023. From their evidence, I am satisfied there was no aptitude test for the petitioners. So 7 petitioners being examined, an allegation or a recording of the case made out by the petition is made on that day that aptitude test was not taken, and they depose that no aptitude test was taken. And my lord, the honorable court, on the basis of the statements, at that stage, my lord, no recording of statement was made or the interviewers were not invited. So at that stage, the honorable single judge forms an opinion that no aptitude test was held so far as these petitioners are concerned. 7 petitioners from different districts. The learned advocate for the board has submitted that he does not have any idea whether any aptitude test was taken or not. He had to take instruction. Now, my lord, comes the next order. These 3 orders are the key orders because I will not trouble your lordship with the entirety of all the orders. Lordship has heard us and I don't want to detain your lordship unnecessarily. Page 423. I directed the petitioners that at least 2 candidates from each district are to be present before this court, as the court wants to know from them about the interview and aptitude test taken by the board in 2016 selection process. I am told by the learned advocate for the petitioners that the candidates are present. Now I start exercising my power under section 165 of the Evidence Act, as I want to take evidence of the candidates from each district. Some names from each district have been intimated to me by the learned advocate for the petitioners who were the candidates in 2016 recruitment process and appeared before the interview board, but all of them are unsuccessful. Well, then Shankar Thamba is one of the candidates who did not appear. Then, my lord, the deposition was taken. Kindly take, my lord,
Shankar Thapa was an interviewer.
No, candidate, right? Candidate, so.
Well, Mr. Partha
Mala, that's a mistake. He's not an interviewer.
So Shankar Thapa was a
candidate who is also a petitioner. Petitioner.
He left, na? You should have caught him.
Or, my lord, he thought that, my lord, if he makes a statement, which will go against the perception of the court, then what happens?
Yes.
In fact, one of the candidates was examined at petitioner, and it was found by the honorable single judge that the statement or the deposition of that candidate, I'll give the names shortly, my lord, that was not a very correct stand. Then I take your lordship, my lord. This is very interesting. Page 425. Now at this stage, when evidence of large number of petitioners have been taken, so 19 plus 7 is equal to 26, and there are about 139 petitioners, and the honorable single judge is of the view evidence of large number of petitioners have been taken, which are throwing light upon one of the allegations of the petitioners. I will not allow filing any affidavit in opposition in this matter by the board. But subsequently, I think board was allowed that. Point is not that. Point is that the honorable single judge thought, after examining 26 writ petitioners out of 139 writ petitioners, examination of large number of the petitioners have been done. Let us take the figure of 26. If lordship kindly takes the figure of 26, this is very interesting. They were about 1,25,000 candidates, subject to correction, who participated.
There are 30 petitioners who
30 interviewers were examined. 26 petitioners were examined. 30 interviewers, 26 petitioners. Well, I have prepared a table, a very short table, which will give the entire picture. Correct? So, my lord, 30 petitioners, 30 interviewers, 26 petitioners. Let us take the figure. If we take the figure of
30 interviewers and
26 petitioners
were examined.
In total.
Yes.
Well, my friend suggests that I continue next day and not to bother your lordship.
But we are not suggesting, Mr.
But my lord, this is a compulsion which we have. What can we do?
Please finish off this.
Yes, my lord. I take your lordship just this part. Approximately 1,25,000 appeared for interview. Again, correct me if I'm wrong. Well, I will stand corrected. By Mr. Tiwari, in fact.
1,25,000
appeared. Out of which, my lord, this 1,25,000 included trained and untrained candidates. Correct me if I'm wrong. Right. About 40, in excess of 42,000, including trained and untrained candidates, were given appointment. In fact, 42,800 and odd. Right? 863.
886.
863, my lord. Something like that, but 800, in excess of 800.
Appointed,
trained and untrained. And also including, my lord, para teachers, ex-servicemen, etc., etc. That is the horizontal part. And, my lord, out of 8,800, about 32,000 were untrained candidates. Which, my lord, the honorable single judge recorded 36. My lord, that was a mistake. That was corrected. That's not nice. That's nothing relevant. What I'm on is that
about 32,000 were untrained.
32,000.
32,000
were untrained. Untrained. So, my lord, we come to a figure which is very interesting. If we take 26 number, it is actually 0.0208% of the total candidates. 0.0208% of the total candidates. And my lord, the honorable single judge, well, I will demonstrate, I will prepare a table, bases his lordship's judgment with due deference to the honorable judge, my lord, extreme highest regard for him I have. My lord, went wrong. Went wrong. Highest regard for him, my lord, highest regard.
Yes.
So, my lord, this is the facts and figure. Kindly allow me, my next day I will be placing the table from how this has happened. And my lord, I will also continue. Whenever your lordship would ask us to come.
Who else is there on your line? You and Mr. Chakraborty. Huh?
This is one big happy family, my lord. Don't abandon us. Both sides.
You are not leaving us happy. We are becoming unhappy day by day.
We will address the specific questions.
Specific questions. Specific questions.
Corruption.
No, Bhattacharya said he would be taking 15 minutes.
That I anticipated that he will be taking 15 minutes.
So
if by Mr. Bhattacharya standard, my lord, I have something to say, my lord.
জীবনে শেষ You may leave. We have finished. So far as your matter is concerned, you have not told us that there are other 2 applications in each of the review. Your junior came and handed over. So you have to reconstruct all, na?
We have the applications, we'll provide all those applications as
No,
well.
no, we passed an order, na? We have to correct it then again. Then we are including, we are treating those on as, how can we treat those in or as matters in the list?
Section 5 can record it at today's list.
কাগজ দিয়েছে তো, অ্যাপ্লিকেশন দেয়নি, হ্যাঁ? অ্যাপ্লিকেশন নাম্বার গুলো ওকে পাঠিয়ে দিই।
আমি সঙ্গে আছি, আমার বন্ধু
সব আছে, লেখা আছে তো, ডিজাইন লেখা আছে, ওখানে লেখা আছে অ্যাপ্লিকেশন নাম্বার।